Commonwealth versus Maloney.
Mr. Steinfeld?
Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth of Massachusetts. We are gathered here today to discuss the interpretation and application of a provision of a statute passed by the legislature last year, commonly known as Maloney's Law. That statute governs cases in which defendants are charged with operating under the influence as a second or subsequent offense, and it specifically deals with the Commonwealth's establishment of a prima facie case that a defendant who has just been convicted of the underlying offense of operating under the influence has been convicted previously of a like offense or offenses. This matters before the Court today on direct appeal of a case reported by a justice of the Peabody District Court, and that justice posed but did not himself answer two questions that are now presented for determination by this Court. The first question posed is whether the ex post facto clauses of the state and federal constitutions prohibit the application of Section 6A to cases that are pending in the trial court on the date that the statute was enacted.
Have you done any research into what the phrase means, alter legal rules of evidence?
Yes.
And what is the result?
Well, it is the Carmel case, the Supreme Court in 99, I believe, its last big case on the fourth category of Calder laws that we are discussing now. In that case, the law, when the crime was committed, said that a victim of sexual abuse, her testimony was not sufficient to support a conviction, that there needed to be corroborating testimony. Then, during the pendency of that case, the legislature changed the law to say that a victim's testimony standing alone was sufficient to support the conviction. The Supreme Court said that that statute was ex post facto because it altered the legal rules of evidence. It permitted conviction solely through the testimony of one witness. That was the law when the crime was committed. And then afterwards, it said, I'm sorry, I think I got that backwards. Before it said you have to have a corroborating witness, then it said your testimony alone is enough. That altered the legal rules of evidence to the detriment of the defendant for the purpose of obtaining a conviction. So did
it alter the legal rules of evidence or the rules with respect to sufficiency of evidence?
Well, that's part of my argument why the ex post facto clause does not apply in this case, that it deals with simply a method of procedure, the presentation of witnesses and evidence during the sentence determination phase.
So you're suggesting that this addition doesn't alter the sufficiency, what is sufficient to convict, but simply what? Simply the process by which this evidence can be presented? Or?
Right. It does two things. It presents a streamlined procedure for that, so that in various cases now you have to go looking for probation officers who have retired, police officers who have retired. And this just makes clear what I argue was in fact the law before, though frankly was misunderstood by practitioners and prosecutors and some judges. There was confusion in this area. But my larger point in that is it doesn't matter what Section 6A says or does. And that is because Section 6A is never used to convict a defendant. And
well, it isn't used to convict the defendant, but is it being used to convict him of a second offense?
No. I would suggest that both the language of the statute that sets out the bifurcated proceeding, Chapter 278, Section 11A, and case law say that that is a trial for the sole purpose of proving an issue, a question, and not to determine whether or not the defendant is guilty of a crime. the case law that goes back to 1824, the first case I could find was the Ross case, and in many, many cases since then, especially Bynum and Pagan and Miranda and Corbett and Murphy, and I think I left one out, I apologize, have all said that a sentence enhancement provision like this one does not state an element of a crime, nor does it state a freestanding crime. And in Pagan, the language that this Court used with a similar statute was following the conviction that occurs during the first trial, the Commonwealth must then prove that on previous occasions this defendant has been convicted. So I think that it is fairly clear from the structure of the statute that the conviction is done and final when the first trial ends. The statute is very clear that there will be two trials.
What do we do with the fact that the legislature used the language trial? I mean, it could have said sentencing procedure. It could have said.
Certainly. That is a consideration, but I don't think that the label that the legislature gave it necessarily means that what happens at that trial is either a conviction or not. I think it's similar to, as you say, a sentencing procedure in which facts are determined. I think they just use the word trial because, as they later say in the statute, they intend to give the defendant all the rights that he would have at a criminal trial. And therefore, they use the word as shorthand for a proceeding. I don't think that they meant it to mean that you are convicted of a second or subsequent offense. I think they intended to say this is solely to determine a fact that goes to your sentencing, and therefore it does not result in a conviction. Therefore, the ex post facto clause, the fourth category that we are talking about, does not apply because the last six words say that it must be in order to obtain a conviction. And I would like to point out that when Justice Chase wrote that opinion in 1798, he italicized the words in order to convict the defendant. And I think that was his way of saying to posterity, we really mean it. And I think under Massachusetts law and that statute, this is simply not to obtain a conviction, is to determine what the sentence is. The sentence has not been changed at all by this provision. The sentences are the same they were as on the day he committed the offense prior to passage of the Act. The only thing that has changed, which I say has not changed, I say that 6A merely clarifies the law, but even if it has changed, it solely goes to the remedy and the procedure, and therefore the ex post facto clause is simply not implicated.
The defendant didn't raise this question, but something that you just said triggered it in my mind. Does Apprendi come into play at all here?
I think Apprendi, I have cited it with a CF in front of it. I think it does come into play merely to confirm that there is no federal constitutional impediment to my argument. Apprendi says that all factors all factors used to enhance a sentence except prior convictions must be submitted to the jury and must be proven beyond a reasonable doubt. Here, the statute gives further protection to the defendant by giving him the right to a trial, and the Commonwealth must prove beyond a reasonable doubt at that trial that he has previously been convicted.
Let me just ask a practical question here.
Sure.
Because you see in various proceedings, people, judges and others, refer to the fact that the defendant has been convicted,
Yes.
previously convicted of driving under the influence, second offense. That's just a misnomer? He hasn't been convicted of that?
It is, I would submit, shorthand, and I've cited a case in a footnote where the appeals court, in fact, did just that. Said so the defendant was convicted of having previously been convicted. I just suggest that it's common nomenclature and it's the practice, but as I say rather conclusorily, but nonetheless true, that doesn't make it so.
Well, except that, I mean, maybe you're stuck with the legislature trying to provide more due process because, in theory, you know, if you've convicted of this one offense and you're convicted of another offense, the judge then goes to the appropriate place to see what the sentence, what the minimum and maximum sentence is. And
Right,
you're
but
saying that the fact that the legislature says in Massachusetts Apprendi is not sufficient, that you really have to have an opportunity to contest whether or not you have been convicted of a prior previously convicted of a driving under offense, that you can do in Massachusetts.
Certainly, you get that added protection under the statute, which incorporates all the protections of a regular criminal trial.
Well, one of the things, I think it is in the other case that we'll hear today, I think the Commonwealth takes the position, couldn't find the first offense conviction, but found the conviction for driving under the influence second offense.
Right.
And basically says that's proof that he's been previously convicted
Yes.
of first offense. So isn't that being used as a conviction in and of itself? A conviction of second offense?
Well, I would say that it is being used during a sentence enhancement proceeding, and that it's evidence that the person has previously been convicted. A jury is certainly willing to, or permitted to reject it. The statute just says that they are allowed to consider it, and that's a question that's not presented in this case, though I do understand that the issue may later arise in this case. I am not the trial prosecutor, but I spoke to the trial prosecutor just to find out, and I think there is an issue in this case. There are 3 prior convictions, one in 1986, one in 1991, and one in 2000, and I believe the later 2 mention the first, so that issue will certainly come up. But I don't think that it necessarily lends support for the argument that you are convicted at a second trial. It is just, and this is my mantra, it is solely to determine which predetermined punishment will be applied. You've already been convicted.
Mr. Steinfeld, this reminds, we have a jury, we have a fact finder. It reminds me, and maybe the analogy is not accurate, between in those states that have the availability of the death penalty, and you send that to a jury or fact finder, and presumably the jury has to find certain facts before it can decide to impose the death penalty or decide not to impose the death penalty. Here you're asking a trier of facts to find that there has been a prior conviction. That doesn't strike me as one's run-of-the-mill sentencing procedure.
Pardon me?
It doesn't strike me as a run-of-the-mill sentencing procedure.
I don't know whether I would use the word run-of-the-mill. I would say that it is common and it is permitted by the state and federal constitutions by the ex post facto clause, which is the question that is presented here.
Has the U.S. Supreme Court ever applied the ex post facto provision of the federal constitution to sentencing provisions or sentencing stages of death penalty cases?
They have said explicitly that it does not apply. In 2 cases that I've cited, Lintz and Daubert. Daubert, I think, is a very, very instructive case. There, the Florida legislature changed the procedure by which someone may be sentenced to death that arguably prejudiced the defendant, made it harder for him to get a life sentence, but made it easier for the death penalty to be imposed. And the Supreme Court said in Daubert, the ex post facto clause does not prohibit the legislature from changing after the fact the determination by which this defendant will be sentenced to death. And I think that, by analogy, if that does not violate the ex post facto clause, then I would submit a proceeding held solely to determine prior convictions would not as well.
You sort of have that in almost every case, don't you, without the explicit provisions of the statute. But if a judge is sentencing, say, a defendant for an armed robbery, the judge looks at the defendant's record and says, oh, by the way, you've been convicted of 3 other armed robberies, so now I'm going to increase your sentence to whatever. The operative principle is still there. All you've got here is that it's been codified in a statute.
Right, and that's what I think the difference is, that here there are several statutes on the books, most notably the drug statutes and this statute, that contain within them
But the subsequent offense provisions provide higher maximums, do they not?
Yes, they certainly do.
They clearly would have to be proved. Different than a sentencing procedure where one says, well, you've got 3 prior robbery convictions, therefore I'm going to sentence you higher up on the scale. This provides a whole different scale.
Right, but it also provides a trial for the defendant to determine whether or not he's been convicted of those. With these other cases, Apprendi provides and state law provides that in terms of prior convictions.
It's whether you were bad in some other kind of way.
It's really,
right.
The enhanced penalties are really not separate crimes.
Right, they are not separate crimes. The cases that I cited earlier all hold that they are not freestanding crimes, nor are they an element of the underlying crime. and therefore do not have to be submitted to a jury beyond a reasonable doubt, but for the statute that permits that. I would like to address briefly the second question, if I may, which involves the power of the legislature to establish what is and what is not prima facie evidence of a fact sought to be proven. Here, the legislature has said that introduction of corroborating documentation is alone and no live witnesses are necessary to prove that prior conviction. I would like to point out, I see my time is low.
Not
I
low,
would like
Mr.
just
Steinfeld, it's
It's
old.
gone.
my time's expired.
I take it your point is the legislature is free to do that.
Right, but also that the question.
No, there are no alsos.
Thank you.
I apologize. Thank you very much, Your Honor.
Thank you, Mr. Steinfeld. Mr. O'Hare.
Morning, Your Honors. My name is Bill O'Hare. I appear today on behalf of Mr. Maloney, the appellee in this matter. And the position taken by the appellee is that the subsequent offense portion of the allegation made by the Commonwealth, when the government moves to present evidence against the defendant on that portion of the matter, that it is not only a trial and a part of a conviction, but it's an element of the original offense, as one of the justices just mentioned. In some matters, when a defendant is found guilty, a court can review their probation department records and what have you, but the defendant in this case was charged with a fourth offense operating under. So the government, when they chose to charge Mr. Maloney, offered up that they would be able to prove the three elements of operating under and offered to prove beyond a reasonable doubt that this same individual had three prior convictions for operating under.
Yes, but Mr. O'Hare, I don't mean to interrupt you, but the rules of evidence are legislative, isn't that correct?
That's correct.
Okay. And the legislature could even abolish the hearsay rule, make us all crazy and have to change everything, but they could. So why can't they simply change this rule? It's a rule of evidence.
Well, they may be able to in a prospective sense, but a couple of the issues raised here for Mr. Maloney's appeal is that it necessarily can't be used retroactively because it violates by changing the rules of evidence that were in effect at the time that he was charged.
Do you concede then as to future cases that the legislature can do this, and the only question here is whether they can do it in an ex post facto sense?
Well, I would suggest to the court that in the prospective cases that then you have brought to bear on the issue as to whether or not other constitutional rights are being violated. And in this particular instance, it would seem if the legislature diminished the burden of proof or removed the obligation of the Commonwealth to present evidence that would prove beyond a reasonable doubt, change the burden, that even though the legislature may have the ability to start down that road, that the other constitutional provisions, confrontation, et cetera, would have this court finding that that was an improper decision by them to change the rules in the way they did.
Mr. O'Hare, could I just go back to the ex post facto? Forget the nomenclatures for a moment. But it seems to me that the jurisprudence underlying ex post facto laws is that you engage in conduct which at the time did not subject you to criminal penalties. It's really a conduct-oriented protection. And so if you do something, if you fish for tiny baby lobsters and you take them out and you eat them, and there's no rule that says you can't do that. The government can't come in 2006 and say you did that in 1999. That's really what is happening. As I say, forget the nomenclatures. Here, your client's conduct wasn't affected in any way. There was nothing that happened in the most recent legislative amendments of which the underlying conduct is the criminal conduct. And it seems to me that whichever way you go about it, it's not an ex post facto application. He might not have known that the fine would be $1,000 versus $10, or that the sentence would be 5 years versus 10 years.
Well, I would come back to my argument about even though the conduct may have been criminal at the time and he was on notice of that, the way to prove that conduct has been changed by...
Well, that's a separate issue. That's a separate issue.
Okay. Well,
The way to prove the proof of the conduct hasn't changed.
If
The
you-
proof of his prior conduct may have changed.
Right,
Correct?
but in terms of this particular case, the punishments would change for Mr. Maloney. So if you're saying that he could still be convicted of operating under the influence, sure, but the government has chosen to bring a complaint that alleges a fourth offense under the statute, which would make for a one-year minimum mandatory. So in terms of ex post facto violations to the criminal
Yeah, but
conduct,
it's not a fourth offense. It is conduct of which he was according to the government, of which he was previously convicted. So there's nothing that he did on whatever night he was arrested or day he was arrested that was changed by the legislature.
But what about
no,
what
no.
about the prohibition against altering legal rules of evidence?
well, in this particular instance, my client was in a position where he was looking at a charge of operating under, and because the statutory language was changed, the proof against him has been reduced significantly. The burden of proof by the government has been reduced significantly by the change in the statute. So,
Explain that to me. Explain.
Well, first of
why.
all, explain why it's a change, because if I take Mr. Steinfeld's point, it's not a change. It may have amended what had become a practice.
well, in Coney and in Toland and the other cases that the court has discussed, in order to prove the prior conduct, the court seemed to require that there be more than mere presentation of prior convictions, but a nexus between those convictions and the defendant before the court.
But we never said that nexus couldn't be established by paper.
And I concede to that, but the identification of the name on the previous cases is not necessarily identification of this defendant.
But that goes to the sufficiency of the evidence, not to the manner of using paper documents. Because I understand here, the statute still requires that the nexus be established, that any prior court documents have to have such things on it as his Social Security number.
Not necessarily.
Something that will tie it in.
I don't know that that's necessarily so, because of the disjunctive way the new Section 6A is written and the practical way that I've seen it applied in the district courts for most of these offenses. The prosecutors are of the position that a certified copy of a prior document under the new Maloney's bill is sufficient under this Section 6A to carry the day for the government, that there's no need for corroborating evidence through documentation of date of birth and what have you. The simple fact that they have a certified copy of a prior...
So the fact that the name that this defendant has also appears on another document, a certified conviction,
Right.
is sufficient. At least that's what you're suggesting the statute suggests.
Exactly, and I'm suggesting to you that your previous decision suggests you need more, which is what you've suggested, that there has to be some documentary corroboration. The last sentence of the new 6A specifically says, once they have the certified copies of the prior convictions and what have you, that there's no longer a need for any corroborating evidence nor live witnesses. And I don't think that's the position of the court on the previous cases, where it's never been required to have a live witness. It has been required that something more than just the
So you have to
certified...
establish that the defendant is the person who was previously convicted. That
Right.
makes perfect sense. And,
And
that's what you're
I
saying.
think...
But have we ever said that live witnesses are required?
But this is not live, correct?
Not to my knowledge that they're required,
But I
but
thought,
in some...
excuse me, I thought the issue was not live witnesses versus not live witnesses, but whether, for example, you can have a certified copy of the conviction and a certified copy of the name, date, birth, and everything else.
Well, the old version of the law required some production of documents along with corroborating information indicating that the document and some other identifying materials connected those documents to the defendant in the room. And the practice was to bring in people to testify.
But it was not a requirement.
I realize it wasn't a requirement, but that was how most of the courts that I've been practicing in thought that they would satisfy the requirements of connecting the documents.
It's sometimes easier to do that than to go get a certified copy of a birth certificate.
And that may be the reason, but the argument that Mr. Maloney is making to the court today is that the new Section 6A, in effect, says that you bring in a certified copy of a prior conviction,
Of someone with the same name.
and Maloney may not be all that uncommon a name, and I attached to my brief a couple of old records from Boston courts where in a much less enlightened time, people were in and out of the courts pretty quickly for operating under, and there's no dates of birth, there's nothing. And so...
But what happened in this case? Didn't they produce evidence that had the date of birth and the prior complaint and other information that...
This case hasn't been tried yet, has it?
It has. I was trial counsel. We went 3 days. The defendant was found guilty. We came back a couple of days later expecting to do our second trial and decide the issue of prior offenses. And the government came with a motion to Judge O'Leary saying, in effect, there's been significant confusion as to what the burden of production is on the government to prove the priors. And here we have a case where Mr. Maloney had cases out of another district court that were old enough that there was no probation officer. His height and weight is average, his hair color is brown, etc. And the government announced, we're going to try to prove this case simply on these certified records. They didn't produce probation records other than the one the Peabody District Court had. And they said, we're not sure if that's enough. We think it's an interesting question that the court may want to address. And so we reported the questions to this court.
But these records aren't conclusive. They're just prima facie evidence, are they not?
Right.
At which point, your guy can get up and say, I'm not the same guy that they're talking about in those records.
Well, he could say that, but normally that's not an avenue available to many defendants.
And part of the question is whether...
The whole point of the statute, isn't it?
Let's call this prima facie. The question is whether it's sufficient beyond a reasonable doubt.
If unrebutted, it is.
That's correct. And I think...
If unrebutted, and the question is whether that is unconstitutional, because it clearly doesn't establish beyond a reasonable doubt.
And I think
that this is that person.
And what we say...
No matter what the legislature says. They could say, proof that a person with the same last name as the defendant was previously convicted shall be prima facie evidence of.
Right.
And we certainly
But we've got
that.
this in other areas. You've got drug certificates that are prima facie evidence that it's heroin, cocaine, and all that kind of stuff.
And as a matter of practice, generally, the name is redacted from the certificate because the certificate identifies the substance and not the fact that the defendant possessed it with any kind of intent, knowingly, and what have you.
It's the or in Section 6A, correct?
I'm sorry, Your Honor?
It's the or in Section 6A, which is the problem.
Right, because I think it extends the prima facie nature of the documents from just identifying that this is a previous, valid, reliable, dependable conviction to it's not only that, but it's this guy or this woman. And what we're suggesting is that's too far of an extension, that it violates the defendant's rights.
Which one?
Certainly.
Which light?
Well, the right to confront the witnesses against them.
I wouldn't go there. Wouldn't go there.
But you aren't contending, are you, that the Commonwealth could not, in any case, produce sufficient documentary evidence which establishes beyond a reasonable doubt that this defendant is the same one who was previously convicted of an OUI offense?
I'm not saying that. There will be circumstances that they won't need alive witnesses, what have you, but the way the new section is written, it basically says if you have one of the 3 or 4 documents, whether they're corroborated or not, we're specifically telling you that you don't need to corroborate them, you don't need to bring in live witnesses. The document itself is enough.
What kind of nexus do you think is necessary? Same address, same name, same date of birth?
Well, certainly those would be starting down the road to getting to that proof beyond a reasonable doubt obligation that the government has. Certainly if it's the same Social Security, same date of birth, and the description is pretty accurate. In the past, that's been held to be sufficient to carry the burden. But in this particular case, the reason it was brought up was because the people involved at the trial level felt that there was not something that we could depend on for identifying what we need to prove, what we don't need to prove. Because of the Coney cases and Tolan saying you don't need necessarily live witnesses, but you need corroboration. And as the government says in their brief, The legislature has changed it to say summarily you don't need to corroborate or to put on live witnesses, and I think it goes too far. That's the
Let's look at the certificate, the drug certificate. What has the legislature said? That that's prima facie evidence that the substance seized contained certain levels of narcotics, right?
That's correct.
It's not prima facie evidence that the defendant possessed the substance. That has to be proved. That has to be proof of a nexus between the substance and the defendant. And that's usually done through, usually, testimony. They got this substance from him. They marked it as an exhibit. They turned it into the drug lab, right?
That's correct.
And that's not what's happening here.
Well, that's what the position of Mr. Maloney is, that it's different.
But the statute just says that the information that's contained in those documents is prima facie evidence of what's stated in the documents, isn't it? Isn't that all it says?
That's all it says.
Right.
But
Well,
I
anyway.
see my time is over. Thank you very much.
Thank you, Mr. O'Hare. We'll take a short break.
All right.